So this case is all about the First Amendment and pushing back against, I think, what is really an insidious and unfair tactic. And so our client is a mom in Oconomowoc, and she became concerned that she thought certain age-inappropriate material being made available through the school's computer system. And she complained about that. And it was addressed at a school board meeting, and she thought that perhaps things had been resolved. But she continued to hear that this material might still be available, the kids were too young for it, that perhaps some things were being read in class that were age inappropriate. And so she sought clarification and essentially didn't get an answer. In March of this year, she testified before the legislature. She related her experience with the school board. There was a later article on a website in which she related her experience with the school board. Everything that she said was true. It's certainly true to the best of her knowledge and ability to figure out. And what the school district has done now is and the board president is they've sent a letter. They've hired a law firm, and they sent a letter saying that she needs to retract her statement and correct it, or she's going to be sued for defamation. Now, public officials can bring lawsuits for defamation, but on our First Amendment, they can rarely ever win them because the Supreme Court has recognized that in order to encourage free and open discussion of public issues, someone can be held liable for saying something about a public official only if that statement is defamatory. It means it has to hold them up in a bad light, only if it's false, and only if they acted with reckless disregard for its truth or falsity. It's not enough that they're wrong. It's basically that they have to know what they're saying isn't true, or they have to act in a way which really reflects a total lack of care as to whether it's true or false or not. Well, that's not what happened here. What she said, I think, was absolutely true, but she certainly made every effort to give the school district and board president an opportunity to have their say, to correct whatever it is she might have been hearing, and that didn't happen. And so, the problem here is if the school board doesn't like what she says, if the board president doesn't like what she says, their answer is to respond to her and to point out why she's wrong. It's not to threaten lawsuits and try to intimidate people who then become fearful of, what it will cost to hire lawyers. I mean, I know lawyers are really, really, really expensive. Not us, but private lawyers. And the prospect that the case could go wrong and you'd lose your house or you'd lose your business. This is just not the way that this is supposed to work. Moms and dads are supposed to be able to come to school board meetings, express their concerns, and we can have a public debate about that. And we don't threaten each other with lawsuits.
Is there any precedent? I mean, are there other school districts in the state or in the country that have done something like this before and been successful?
We're beginning to see some of that happening on the part of school districts around the country. I mean, there has been, particularly post-pandemic and with the rise of, for lack of a better term, a more woke ideology on behalf of some school administrators. There are a lot of parents that are frustrated and concerned. They don't like the direction in which their schools have been heading, and they're complaining about it. The proper way for elected public officials to react to that is to say, okay, we're going to respond to what you say. We're either going to take into account what you've said and see if we can do better, or we're going to tell you you're wrong, and we're going to explain why you're wrong, why we feel that we should proceed in the way that we've been proceeding. But what you don't do, unless they have said false and defamatory things without any regard for whether they're true or not, you don't threaten them with lawsuits, because that's not how we resolve problems in the United States of America. This is a democratic republic. We have debates. People are free to say what they want to say. And if they constantly have to hold their tongue because they're worried that somebody will lawyer up and somebody who's got way more money will go and hire some white shoe law firm in order to throw its weight around, I think that's just something that ought not to be done. And so we've called them on it. And you know what, Meg? I am fully confident that they will back down because they don't have a case. They can't make a case. They know they don't have a case. And I hope that this is a tactic that they will reconsider and we won't see it anymore in the future.
Has the school district denied the existence of these age-inappropriate materials in the classrooms?
Well, we start then to get into, a conversation about they clearly were available on the school's computer system at one point. The school district said it was going to remove that. Perhaps they did. But then there was another book that was read out loud in class, and the question as to what portions of it were read. I would have to say that certainly compared to what was available in libraries when I was in school, it wasn't stuff like this. I'll just leave it at that.
Well, what's interesting, too, is that they felt it was necessary to hire an attorney that is paid for by the taxpayers in Oconomowoc to go after this parent, which, I mean, as you've already said, it sends a chilling effect to other parents that want to speak up and defend their children and defend what they perceive as being something that's inappropriate in their child's classroom.
There's a thing I think that we should clarify here. This isn't about book banning. This isn't about whether these books are protected by the First Amendment. They are. You can write a book like this. And if there are parents out there who want their children to see this material, well, they'll be able to see it. But the question that our client was concerned about is what type of control should parents have over what their younger children see? And that's the issue that she wanted to raise with the school board. But this case, right, this particular incident that we're talking about, isn't even about that. The question here is whether or not she has the right to come forward, express her concerns that, she took due care to investigate and take steps to ensure that what she was saying was accurate and fair. Whether or not she can do that, whether she can be a concerned, active mother without being threatened with a lawsuit. And she should be able to do that. And she will be able to do that. They're not going to prevail. They're not going to successfully sue her for defamation. They should know that. But if they don't know it, they'll find out.
Well, and I think really this win for Wisconsin Institute for Law and Liberty on behalf of this parent will be a wake-up call for other school districts, I think, because if there's a silver lining, dare I say that, I don't even like cliches, but in this entire COVID experience over the last 2 years and children in this horrible virtual learning environment is that parents' eyes have been opened to what's going on in their children's classrooms and the material that's being used. And I think now parents will look at this, and in the case of this particular mom in Oconomowoc, the parents will look at this and say, you know what, now I will have the courage or the ability or willingness to stand up and speak out as well. And that's, I think, what should be the message in all of this is that her First Amendment right to protect her free speech and her willingness to speak out and call out the school board in this case is effective. It should be protected.
Right. I'm confident that will be the outcome here. The reason that we have to do this and the reason that we have to send a letter and the reason that we have to make the letter public and come on the radio when you're nice enough to invite us is that there are a lot of parents out there that aren't like Allie, and they'll get intimidated by something like this, and they'll decide that the better course is to not say anything and to just give in. And I don't blame them for that. It's a scary thing to get a letter from a lawyer, but for those people like Allie who are willing to step forward and who are willing to stand up, I think that it's important that other people see that you don't have to give in like this, that you do have a right to participate in the processes of your local government, your public bodies, your school districts, and you do have a voice. In our country, you're free to use that voice.
She has now proven that she's not going to be bullied into silence, and that's another thing that's a great example that she's setting for other parents is to stay strong and to be willing to find their voice and to speak out when they determine that there's something that could potentially harm their children. We are, as parents, our best children's advocates, so we have to be speaking out. So do you anticipate that this will be resolved somewhat quickly?
Yeah, I don't anticipate that the school district won't proceed with its threats. And, I could be wrong. I've been doing this for a long time. And I can't always predict what's going to happen. But I think in this case, cooler minds will prevail. And they will come to the conclusion that this is not an appropriate way to proceed.
This was more than likely just a threatening letter to get her to stand down, and they didn't anticipate that she would retain the awesome legal team from Wisconsin Institute for Law and Liberty.